Uh, oh,
Sorry.
thank you. We have elder law attorney Dan Tulley, who has joined us for these meetings in the past. Attorney Tulley is always a wealth of knowledge, and we always get very positive feedback about our meetings. He's part of the law firm Kilbourne and Tulley and has offices in Bristol, Glastonbury, North Haven, and Stamford. Before we start, I just want to remind everyone that there is a limited time and we will do our best to accommodate everyone's questions. But please remember that there are others waiting to have their questions answered as well. Attorney Tully, thank you, and the floor is yours.
Bernadette, thank you. Thank you, Kevin. You know, it's always an honor for me to speak to CSEA. I've always admired your ability to come together and protect your members. And, it's always a joy for me to speak to the group because I know you have quite an attentive group. I just want to give a little bit of my background for those who may not know me. I'm a former Assistant Attorney General for the state where I worked for Senator Lieberman when he was the Attorney General. I'm a former board member of the National Academy of Elder Law Attorneys. I'm also the former national chairman of the Senior Rights Political Action Committee. We have a column in 3 newspapers in Connecticut that comes out every Tuesday in the Bristol Press, the Britain Herald, and the Willimantic Chronicle. And it's, like I said, it's an honor to be in front of the group today. If the individuals, we'd be happy to speak to some of the local CSEA chapters, and we obviously speak for free all the time. Just so that people want to get in touch with us, they can reach us at KT Elderlaw, ELDERLAW.com. Like so many of you, I want to pass something along to the next generation. Tomorrow, it'll be this little guy's 2-month birthday. That's my grandson, Jack. And yes, I already did buy golf clubs for him. And I want to be able to pass something along to the next generation like all of you. And if I lose everything that I've worked my lifetime for through long-term care, I won't be able to do that. So that's something that's near and dear to my heart. And I know so many members. I'm glad I have the opportunity to speak to the group today because I'm very concerned about the big, beautiful bill and its negative impact on seniors and the Medicaid system, which could also affect long-term care agencies, long-term care facilities. I was going to talk about how there's black clouds on the horizon and we've got to be prepared. But I'd rather say to sound the alarm because it's here. It's already law, and we're going to start seeing its negative effects in the not too distant future. There's still many things that can be done for seniors and your members to protect themselves. We're going to go over that today. And the big, beautiful bill will have disastrous impact of nearly $1 trillion in cuts to Medicaid. Now, where's that additional funds going to come from? It's going to come out of the state budget, and it's going to be a real problem. I just want to note that this is the largest tax break to billionaires in American history. So I'm sure you're all concerned and happy that Bezos and Elon Musk can have their 3rd or 4th super yacht, but it's really going to hurt the average person. Medicaid provides funding for nearly 60% of all nursing home residents in the United States. It is a huge program, and that's why it has become a target. The United States and the state of Connecticut already faces severe shortages for long-term care for our aging seniors. Right here in Bristol, one of my offices, we have 2 nursing homes that are closing. Those are 2 significant amount of beds that just aren't going to be available any longer. We're seeing nursing homes across the state and across the country already starting to close. We're seeing some nursing home turn people away, prospective residents, due to staffing and funding issues. So that's a real concern, and it's here, it's happening right now. I don't want to be all gloom and doom, but it's important that we understand that this is not just something that is in theory. It's real, it's happening right now. And another thing that's threatening is cuts to the home and community-based services. Many are likely to agencies are likely to close their doors or reduce services. And that's something that I'm kind of proud when I meet elder law attorneys from other states that we have a pretty good home care program here in the state of Connecticut. And if our members are not aware of that, you can receive up to 24/7 care in your own home, so you never would need nursing home care. Again, that will be threatened with a $1 trillion cut to Medicaid. What do we do with this? What's our next steps? How do we prepare? Well, one of the things you want to be is proactive. You want to have your documents in order, and I'm going to go over in a moment what ones you should have. You should get educated like you're doing right now. Again, you have a wonderful organization of folks who go the extra yards to find out what their rights are, which is fantastic. Be careful who you're listening to. Even if somebody is well-intentioned, they could be giving you horrible examples of what to do. We see that all the time when some people talk about, well, my sister in Chicopee, Mass, this is what she did. Well, Massachusetts and Connecticut, two entirely different states, two entirely different rules for Medicaid Title 19. Even though it's a federal program, every single state is different. You wouldn't believe some of the things they can do in Florida and we can't do here. So you want to be careful who you talk to, because even if well-intentioned, they could be giving you horrible, horrible advice that could cost you thousands, sometimes hundreds of thousands of dollars that you don't have to spend down to get eligible for Medicaid Title 19. You have to be aware of people who have a conflict of interest with you. I'm seeing that in a lot of what we call Medicaid application companies. I've got no problem with competition. We've got plenty of work. I've got a real problem if I see a married couple with a home and $500,000 in their name and they spend 400,000 that they don't have to. That's really unethical as far as I'm concerned. And a lot of these Medicaid application companies, their pitch is to long-term care facilities is that, hey, we'll get the people to spend as much money as possible. So you want to be careful about that. You want to be proactive. And here's an example of how the long-term care industry is being proactive. I was putting together some of my material today. There's a national law firm that supports skilled nursing facilities, and they were giving out a newsletter saying that the facilities that proactively prepare for potential changes will be in the best position to navigate the evolving landscape. Well, we could change that from saying facilities that proactively prepare to individuals and families who proactively prepare will be in a best position. Why shouldn't we prepare? Why shouldn't we get ourselves ready as opposed to just big business? And one thing to remember too, you got to vote. We have to get out and vote. And there are still some chances that some of these really horrific law changes can be changed in the midterm elections and the upcoming down the road presidential election. So a couple of things I want you to take away from my speech here today too, that just are common sense things for someone like myself who does this every day, but something that we may not think about. If we need care at home, if we need care in assisted living, if we need care in skilled care, you should be careful not to allow your adult children to sign anything. Specifically, if there's an admission agreement and they're signing as a responsible party, and if during a Medicaid application there's any problem whatsoever with the application and it gets denied, your child will be sued. There was a case right out of Glastonbury, not one of our cases, where a son admitted his mother to the facility, signed as a responsible party, which we always say don't ever do, then made the huge mistake of trying to do the Medicaid application himself, and it was denied. Mom had no money left. The facility sued him to the tune of $125,000. He lost and had to go into his retirement and pay off a bill that he had no liability whatsoever for, but he obligated himself to do that. So please be careful. We see that stuff all the time. You know, a lot of folks, and I'm not trying to paint, anyone who works in the long-term care industry with a broad brush that they're out to get you. And a lot of them are fine and compassionate people, but there's a conflict of interest, and you want to be careful of that. And you want to make sure that if someone says, oh, you have no liability, get a second opinion, because you don't want to burden your children with that. You're not responsible for their bills. They shouldn't be responsible for yours. We talked a little bit about the Medicaid application companies. You really want to be careful with that, because they are not looking out for your best interest. They wouldn't let an attorney represent the facility and the individual at the same time. Why would you let a Medicaid application company? They're not doing what's in your best interest. They're not going to tell you everything that you have to do. Again, we write a column at least 2 or 3 times a year in our newspaper column, and it gets the nursing homes all upset with me when I tell people don't sign it, but that's okay. I represent the families and the individuals. I don't represent long-term care facilities. We want folks to know the differences when we talk about Medicaid, and I'm going to get a little bit more into this too. the difference between if we're married or if we're single, a widow, a widower, because the laws are vastly different. Um, Trusts are not necessarily the cure-all. They're not going to make you grow hair and look thin and be younger. But sometimes people think trusts are the ultimate answer, and that's not necessarily true. And sometimes we can make our life a lot more complicated. In some cases, it's appropriate. If we have an adult disabled child, we do need a special needs trust. If we have a spouse who's disabled, we do need a some type of trust also. So there's situations where we would need a trust, but it's not one size fits all. And that's often how it's presented. Um, and again, we want to make sure that everyone knows that if you need long-term care, you can stay in your own home and under the Medicaid program. And again, you don't necessarily have to spend down every dollar that you have to become eligible. Let's go back and talk a little bit about what to do to prepare. The first thing that we should know is there's certain documents that's going to make our life a lot easier if we're able to step into someone else's shoes or have a family member we trust take care of certain things. We should all have a power of attorney, a durable power of attorney, which would enable your spouse, your child, your friend, your loved one to be able to make financial decisions for you. It's extremely important that you have that because that's a way in which you'd be able to not have to have a conservator. A conservator is expensive, it's time consuming, and some of the planning options that are available to you might be lost because uh, when we have a conservator, it's a lot more formal, it's a lot more expensive. So we always want to make sure we have a durable power of attorney. Little warning with that, we always say if we have three kids, one's a doctor, one's a lawyer, and one's living in the basement wearing the Foxwoods jacket, that's probably not the one you want to appoint your power of attorney because the power of attorney has broad and sweeping powers, and we want to make sure the person we're appointing is responsible and is not going to treat your money as their own. For healthcare decisions, we need a healthcare representative. Who would know better than your family, your loved ones, your friends, what your medical decisions are? And you want to make sure that someone's going to reflect what you want to happen during your lifetime. You can think of a scenario where you might have a conflict of interest with a doctor. That may not be what your wishes are, maybe what philosophically their thoughts are. Remember in these documents that they can always be changed. We've seen over the years, and we've been doing this almost 38 years now. We've seen over the years that some people don't get documents because they're afraid, well, if I appoint my son, he's going to put me in a nursing home. Well, he really can't. Someone you appoint as power of attorney healthcare representative has to act under what they call a fiduciary capacity, meaning they have to do what's in your best interest. In addition to that, those documents can be revoked at any time. They can be changed at any time. It's more important that you have them than you do not have them. With a healthcare representative, you are in charge until you're incapable. So even if you're in tough shape physically, you're still calling the shots, not anyone else. But it's important to have a spouse, children, adult children, friends, somebody, relative, someone who knows what your wishes are. We all should have a living will so that it makes decisions easier for our loved ones if we're going to pass soon anyways or we're deemed to be in an irrevocable coma. In order for them to make an informed decision, you want to make sure that they have a HIPAA or a privacy form. And all these documents can be done at the same time. Oftentimes we get questions about, like I mentioned before, what's more important, a will or a trust? Well, in some cases, as I just explained, it would be very important to have a trust. But in many cases, if we just have a simple will, that's sufficient. And one thing I tell a lot of people is the biggest concern for most seniors is not avoiding probate. And we see that in the newspaper, we see ads, we see seminars. Right now, if we're under $12 million, there's no state or federal inheritance tax. So what's the bigger concern? Well, the bigger concern would be if we needed skilled nursing care, nursing home care, it could be up to $20,000 a month. That's a bigger concern for most of the people I see. Most people don't need an elaborate trust to avoid probate. There may be reasons for that, but it's not one size fits all, and we seem to be getting that question a lot. In some cases, it's appropriate. If you wanted to put your residence into a trust, if you wanted to put the family cottage into a trust, but again, if we transfer something out of our name under the Medicaid laws, it's a 5-year look back. whether you put it into a trust or you put it into your kids' names outright. And just like the power of attorney and the other documents, you want to be real careful about putting that your home, your residence into your child or children's name, because that son-in-law or daughter-in-law that you just can't stand could be kicking you out of your own home. And we've seen it, unfortunately. That's why we always insist that people who transfer assets have a life use agreement, which says, I have the right to live in my house for the rest of my life. One thing to keep in mind that people don't always know is if we're talking about a married couple, if there's one spouse living in the house is exempt. It's not counted. It can't be touched. It can't be liened. So as long as there's one person living in the house, it's an exempt asset. So a lot of people feel a little bit easier when they hear that. And some people just say, I don't want to put it in my home in my kid's name. I don't want to be a burden on my children, and I don't want my children to tell me what to do with my own residence. So that's something that we want to be careful of. In a lot of cases, it's important that we have the will or the trust in place. But again, just like we said for the other documents, whoever your name is your executor, who's going to be in charge of your estate, pay your last expenses. You want to make sure it's one of your children that you trust, or a family member or a friend, someone who's going to come through and get things done for you. And again, probate in Connecticut is not as big of a deal as the cost of long-term care. And just like the Yukon Women Husky, we're right near the top for the most expensive uh, states in the country for the cost of long-term care. So it's a real issue here. As I noted before, it's important that we get educated, that we know the differences between fact and fiction. When sometimes in our column we write articles about myths associated with Medicaid and long-term care, because there's a lot of myths out there. And once you sometimes hear a presentation like ours, or read an article, which you want to be careful of, because you could be reading an article that's written for a national audience that really doesn't pertain to the state of Connecticut, or it may be an article written out of state by an out of state attorney that the laws are different. One thing I can tell you is we have an office in Stamford, and in New York State, which is just a few miles away, the state of New York cannot touch your retirement accounts if you apply for Medicaid Title 19. That's not the case here in Connecticut. It's your retirement accounts are up for grabs, but that doesn't mean you necessarily have to give away everything. We talked again before about being careful who we listen to if someone has a conflict of interest with you. One thing I just wanted to note about when we talk about Medicaid, and I'd like to talk a little bit about the basics of Medicaid, is that there's different rules, unfortunately, for widows, widowers, and single folks than there are for married folks. Let me tell you an example of a married couple. If a married couple owns their own home and has far more than what they call the community spouse protected amount, which currently is around 157,920, you can have far more than that and still be eligible as a married couple and not have to spend down. And oftentimes people are not told that. And that's something that oftentimes gets my Irish up. And when we talk about people giving you bad advice, sometimes it's attorneys that say they're an elder law attorney and they really don't know what they're talking about. We had that case recently where a young gentleman had to go into a nursing home. He was 65. They did pretty well for themselves. They had a home and $600,000. The wife went to see an elder law attorney or someone who claimed they were. And the elder law attorney told them, listen, you have to spend $500,000 before your husband can receive any benefits. Well, the wife started spending $15,000 a month on the facility. And one day she was upset and complaining, as I would be if I was spending $15,000 a month on my wife's care. And as luck would have it, her husband's roommate was our client. And this adult son was there and said, you better go see Tulley. Well, she came to see me and I felt horrible because she had spent 300 of the $600,000 they had already, and I couldn't get that back. But we were able to protect the entire $300,000 that they had left. I could have done that with 600,000, and it's perfectly legal, perfectly ethical, and it's right in the federal law how that can come about. Now, sometimes we hear the horror stories about a widower, single person that they had to sell their house and spend down all their assets till they get down to $1,600. And that's true. But there's also something called exceptions under the Medicaid laws, where if you have an adult disabled child, assets can be transferred without any penalty at all. There's something called the adult caretaker child. And you know, the biggest caregivers in Connecticut and across the country are not nurses, they're not doctors, they're not social workers, they're not CNAs, it's family members. And oftentimes these are uncompensated individuals. And people may say, well, it's my mom or my dad. I don't want to get paid. That's not the point. The point is this. If you weren't doing it, somebody else would, potentially with a fraction of your education experience and getting more per hour than you'd be entitled to. Children, adult children, are entitled to be compensated for providing care for their parents. It's a way to spend down without losing anything. And as a matter of fact, if an adult child moves in with a parent, if a parent moves in with a child and they do it for over 2 years, there's an exception that enables a home to be transferred or monetary amount without a 5-year penalty. And a lot of people are not aware of that. And a lot of people spend thousands, sometimes hundreds of thousands of dollars again, that they don't have to. You don't have to go broke if you need home care or you need nursing home care. And I want to reiterate one more time, you can receive care in your own home, and the rules are the same, where you can protect far more for a married couple than 157,920, and you can protect in some cases, if there's exceptions that exist, for the individuals. Now, a lot of people say, I've got too much money, I can't become eligible for Title 19. In a lot of cases, in most cases, that's just not true. That there are ways that you can receive it. And I guess one way to think about it, and I just wrote an article not that long about the ethical considerations of protecting your assets. And some people say, I don't want to break the law. I don't want to, do what's not right. Well, you've paid more than your fair share of taxes. You've paid into the system. Medicaid Title 19 is a safety net for the middle class. And many times people don't take advantage of legal exceptions that exist to them. And it's kind of sad that that happens. And sometimes people think, oh, I've got too much money. I don't want to be breaking the law. Well, listen, I wouldn't put my law license at risk to show someone to do something if it wasn't legal, if it wasn't ethical. And, there's no difference between trying to protect what you've worked your lifetime for than what the Kennedys and the Rockefellers and the Trumps try to do in elaborate tax planning that saves them millions of dollars. So that's why families, they should consider it. And sometimes they don't apply for the benefits when they do it. And Medicaid's got a bad reputation that it's only if you're broke, and that's not the case. A couple of things I just wanted to point out to you that, you know, common practice that we see all the times. Again, sometimes you may have financial advisors who are more concerned about what they're making from you than giving you the best advice. I had a case many years ago, right before the law change, when we went from a 3-year to a 5-year look back in 2006. And this woman had 5 daughters and she had $500,000. And she wanted to give each daughter, before the law changed, $100,000. And I didn't really think that was such a great idea, but this was her money. This is what she worked for. And the financial planner talked her out of it. And soon thereafter, the law changed. And soon thereafter, she got ill and she went through the entire $500,000. Again, we want to be careful we don't have a conflict of interest with anyone. So that's something that you want to be careful of. Also, sometimes financial advisors say, well, you can self-insure. Well, you have to have a heck of a lot of money to generate $20,000 a month if you were paying for skilled nursing care. That's an awful lot of money. You've got to have an awful lot of money to pay that. Sometimes people put their children's names on their accounts and they think that, well, it's protected, at least half of it, parts in my name and parts in Junior's name. That's not how it works. Under the Medicaid program, unless your child can prove contribution by your putting their name on the account, it's great for accessibility, and if there was any problems with power of attorney, and that's an important point to bring up, is that one of the reasons you want to work with an attorney, an elder law attorney, and getting these documents done, is we have clients coming back 5 and 10 years and many years later that we're stamping the document and saying it hasn't been revoked. So that way, that's the difference between do it yourself or fill in the blank documents are really dangerous. I've seen too many times people who've had wills, powers of attorney, health documents that are improperly witnessed, improperly notarized. So what do you have? You have nothing. If it's not valid, there's nothing you can do with it. So you want to be careful, but putting your child's name on your account does absolutely nothing uh, to protect those funds. Now, the opposite is true of real estate. If you put your child's name in the real estate after 5 years, half of that would be protected if it's in your name and their name, or put it in name alone after 5 years it would be protected. But again, please don't do it without having a life use agreement, because you really want to be protected, and legally the house is no longer yours. Um, Also, we oftentimes see that, people have a will and it says, we want to give the cottage down in Old Lyme to the kids. And then somebody gets sick and they say, well, they can't touch the Old Lyme property because it's in my will. That doesn't mean anything. Our wills don't mean anything until we pass away. In the ballpark of Medicaid planning asset protection, if that property is still in your name, it's going to be counted. Now, that's different than when we talk about our residence. Our residence is exempt, not our cottage in Old Lyme. Okay, so that's something we want to be careful of. And some of you may have worked for DSS. The state counts everything when we're talking about Medicaid planning. It doesn't matter if it's in the husband's name, the wife's name, joint. It's all gets thrown into the pot and is considered as being an available asset. So that's something that we want to keep an eye on. So Medicaid can be confusing, and it's changing all the time. Again, we're very concerned about where we go from here and what some of the changes that could adversely affect your members and a lot of seniors throughout the state of Connecticut and the country. One change that I'm also very concerned about, and it's a law now, is that when we apply for Medicaid Title 19, we can go retroactive 3 months prior to the month in which we're applying. So here we are in September. We could go back August, July, June. So we could all the way to June 1st. That's changing from a 90-day or 3 month look back to a 60-day look back. And you may say, well, that's not that big of a deal. It really is. And here's why. Oftentimes people don't know when Medicare has ended, even though it's supposed to be in writing. And sometimes facilities are a little bit lax on sending out the billing. And the next thing you know, families are scrambling to try to get a Medicaid application in so they can have the retroactivity. And if you're only going back 60 days and not 90 days, that could be a real huge bill that a family would be liable to pay because there's no retroactivity. And that's part of the concern too, is that one of the changes for the big beautiful bill is that there's going to be less funds available, and we may have heard of block grants before. What that means is the state of Connecticut and many states are going to receive a finite amount of money, and we're going to have to sink or swim with that. And that's going to be a major, major problem. There's been some discussion about creating additional taxes. I don't think that's going to happen. It's just going to be less services, both in skilled care, less beds available. One thing that I'm very concerned about is the staffing levels. It's kind of at dangerous levels right now, but if there's less staffing, you're going to see more cases of elder abuse, more injuries, and it's a dangerous situation. It's a slippery slope. And, in light of making these cuts to fund billionaires, it's kind of reprehensible. But we have to deal with what the law is, and that's what the law is, and that's why this is not theory, this is reality. Making sure we have the documents in place, and making sure we know, what our rights are and what we're entitled to. We paid our taxes, we can protect our assets. Making sure that we're getting the best possible advice on what we've worked our lifetime for and wanting to protect it, and being proactive. Those we see that get their documents in place and find out what the law is, and asking for a second opinion, or you feel like you're being pushed a little bit too much by the facility or the home healthcare company, take a step back. I'd like to review this. I'd like to get a second opinion. And that's when, you can find out in many cases that what you were being told is completely not true. So I'd love to open it up to questions specifically, hopefully about, documents, Medicaid, Title 19 planning, and see where, if we can point you in the right direction. And again, we'd love to come out to the local chapters and speak there. Kind of miss doing that because after COVID, that kind of changed. But it's always enjoyable to get in front of a group and answer their questions and speak to them.
We'll make sure that happens, Attorney Tully.
Right,
Thank you.
right.
Can we start with some of the questions that were in the chat? And I'll go
Sure.
in order. What
Okay.
age do you stop paying capital gains taxes when selling a home?
Well, in most cases, the capital gains tax, and again, I'm not an accountant, I'm an elder law attorney. In most cases, the homes are lower than the capital gains tax before it would kick in, which I believe is around $500,000 or higher right now. And there are ways in which you can capital gains tax is based upon what you bought the property for and what you're selling it for. And oftentimes, if you've done the roof over and made major changes to the house, that increases what they call the basis in the property. So, in a lot of cases in Connecticut, it's not a big concern. If you are in the process of selling your house, you're thinking about it, you may want to sit down with a CPA and just make sure that there's no surprises at the closing table and someone comes looking for taxes from you.
I think this,
Another question. Oh, go
oh,
ahead, Kevin.
I think this one might also be a question for, financial advisor, but what are some good ways to manage required mandatory distributions and not pay as many taxes?
Well, again, it's probably maybe a question for a CPA, but if you have any healthcare costs, if you have any legitimate deductions, you want to make sure you're taking those. And some of the healthcare costs can weigh against the RMDs that you have to take. And sometimes people have Roth IRAs where they've already paid the taxes, so they're alleviated from having to concern themselves with that. Um, some of the hardships we see sometimes is that if a substantial amount of your funds and most people it's your home or your retirement account, if one spouse had all the money in their retirement account, the state could care less if we're talking again about Medicaid Title 19, then they would force you to take those funds out regardless of the taxes. However, there is a way through the court system that we can go in and ask for a court order to transfer the asset from husband to wife or wife to husband and avoid some of those taxes. It is a little bit cumbersome. It takes a little bit of time through the court system, but we've been successful in doing that before.
Another question was, what liability would the beneficiaries assume if a person signs a solar energy contract for 20 to 25 years and they die before the end of the contract period?
Best answer I would have for that, it would be dependent upon what the contract says. It could be passed along to the estate and it could be a lien on the property that would have to be addressed before the property were sold. And sometimes that's true with some municipalities giving you money for sewers and things like that. That would be taken care of out of the if there were the real estate before the closing could occur or at the closing table.
So they really have to read the fine print of the contract and
Right,
make
and if they
clear
if they
when they're signing that contract or ask that question before
right,
they
or if
sign
it's
it.
already signed, get a copy of it. So
Do
Uh,
you,
oh,
oh, go ahead.
an iPad user asked, does KT Elder Law do revocable and irrevocable trusts?
yes, we do. We do revocable and irrevocable trusts. Again, we don't like to think of it as a commodity that we want to sell something to someone. We want to make sure you understand it, you're comfortable with it. And again, I'm not saying that trusts are a bad thing, but almost as long as I've been practicing here in Connecticut, there have been these seminars about how you can avoid probate. And again, a bigger concern is the cost of long-term care than avoiding probate in Connecticut. But there may be very legitimate reasons to have a trust if we have a spouse who's incapacitated already, if we have an adult disabled child, or we have, several pieces of property in several different states. That may be something that would be more appropriately handled through a trust. But yes, we do trusts.
Another person asked if this was just for Connecticut or every state, and I think you're specific to Connecticut.
I'm specific to Connecticut. I have a lot of colleagues that I've met throughout the years in other parts of the country that unfortunately their states are much more favorable in allowing assets to be protected. And if you were to move, say, from Connecticut to Florida, it would be advisable to consult with a local council down there because there's different rules. And I can tell you, and in dealing with Florida Council, and we do work with them in many cases, that unfortunately or fortunately, if you are in Florida and you own a home and you're a Florida resident, and that could be homesteaded or protected, that where the state of Florida can never take that away from you, which is not the case in Connecticut. So,
Yeah, we
and
had
I don't work for the Florida Board of Tourism.
we had a couple of people, one person planning on moving to Rhode Island, one person moving to California. Do you have any advice on finding a decent elder law attorney out there in those states?
Absolutely, I would go to that National Academy of elder law attorneys. I sat on that board for many years. That's attorneys that work, in the area and are familiar with it. And as a consumer, you may want to just ask them questions. How long have you been practicing? What type of practice do you have? Do you do Medicaid Title 19 applications? You're the consumer. You have the right to know, what someone's credentials are and what their experience is, because in a lot of states, anybody and his brother can say they're an elder law attorney, but as someone who obviously does 200 applications, Medicaid applications per year, probably has a lot more experience than somebody who does two. So, but that would be a great place to start.
Great. Somebody else, Luis asked, do the power of attorney and healthcare representative documents expire?
Very good question. They don't expire, but circumstances change in our life, and the person or persons we may have appointed in the past may not be who you want in charge of it, which is sometimes a good time to revisit who you've appointed and whether they're still the individuals you want. Again, if it's been done by an attorney, it's following the proper witnessing and notarization, as opposed to pulling it off the internet. There's all kinds of problems when people do the do-it-yourself documents, and it can be an absolute nightmare. Going back to my years at the Attorney General's office, we had cases where people would come in and it would be a mess, and we'd say, "Sorry, you're not protecting this asset. You can't transfer this asset because your power of attorney is invalid." So you want to be real careful about that, but they don't revoke. As far as the healthcare documents, we always send out plenty of extra copies, and it should be shared with your medical professionals as part of your file. When you're going in for surgery is not the time to be signing legal documents. You want to make sure that they have that in advance, and they know what your wishes are in advance.
There was a question, what if the home is in only one of the spouse's name?
It's a good question. If it was in only one of the spouses' name, it could still be an exempt asset. Sometimes it gets a little bit complicated if it's a second or third marriage, but the home can be protected even if it's in one of the spouse's names. And there's ways to do that and make sure that you're not selling an asset that you don't have to sell.
And they should see an attorney for the best way
That's
to do that.
right, an attorney experience in this area of the law.
There's a question about the Connecticut Partnership Long-Term Care, and is it still worth it? Is that something you're familiar with?
Absolutely, I'm familiar with it. Yeah, I know. I think long-term care insurance is a great thing, and I know throughout the years the state of Connecticut was advocating for state employees to get it. The thing that, again, gets my Irish up is I get very upset when I see my clients coming in who've been paying religiously for 20, 25 years on their long-term care policy, and now they're being told that the rates are going through the roof, or if we'll reduce the rate as long as you take half the coverage. Well, why did I have it for 20 or 25 years? Why did I do what you told me to do? And now it's almost like I'm being penalized to try to keep the same benefits. I mean, I'd be remiss if I told someone to drop their long-term care policy, because in some cases we've seen some fantastic stories. I remember we had a case where a single school teacher had long-term care, and it kept her in a beautiful assisted living facility for years and years where she didn't have to pay a thing. There's other times that long-term care can pay for home care. And the one thing that I always tell people who have long-term care, make a claim as soon as you can, because then you can stop paying on the premiums. Don't assume that you're not eligible. Make them tell you you're not eligible. I hate to see someone taking less coverage, but in some cases that may be the only way that they can keep the coverage. I've been wanting to speak to Senator Murphy and Senator Blumenthal about, this is outrageous that every year it's keeping to being revisited, that they're pricing seniors out of the market, people who've done what they've supposed to do, and now it's not cost effective anymore. But the partnership is alive and well. And just as a way of explanation, let's say you had $100,000 worth of coverage. The policy paid out $100,000. You have $100,000 in the bank. That's all protected. Even if you're a single person, that's money cannot be counted because you have the partnership protections. And that's one of the things that's written right on your policy, your long-term care policy, that this is a partnership policy. And I have to say, Connecticut was at the forefront, one of the few states that had this partnership policy. Now, all states have it, but it's still in existence. It can be expensive, but depending upon what your circumstances are, whether you can afford it, in many cases it makes sense to keep it. So
Is it better to have some assets when you need to move to a long-term care rather than seeking a room as a Medicaid patient?
excellent question. And again, one of my concerns about the recent changes, and if you were to go try to put your name on the wait list of some of these long-term care facilities, someone will say, "Oh, we have a 2 or 3 year wait list." But if you showed up with $100,000 in your pocket, you'd be in by 5 o'clock tonight.
Hmm.
That's a concern, and we call that seed money. It shouldn't exist that way, but that's the way it does. Connecticut has something called the wait list law. And what that means is you're not supposed to take private pay over Medicaid pending patients. But if you have the requisite number of Title 19 patients, and they all do, they can always take private pay over the Medicaid pending individual. So in some cases, it does make sense, but don't get discouraged if the facility that's near your house that you think is more desirable is telling you you've got a 2 year wait list. That doesn't necessarily always have to happen, and there are some other ways sometimes to get into that facility without having to wait that long. But it does make a lot of sense if we're in failing health is to get on the wait list. And the issue there is even if you came to the top of the list, it doesn't mean that you have to accept that and you don't drop right down to the bottom. You stay right near the top. And it gives you and your family options. And that's what something we always want is you may get a phone call or your family may get a phone call when you're at your wit's end that you really need skilled care now, and now they have a bed. So it's a good thing to come to the practice of. But again, do not have your children sign anything that has to do with an admission agreement because that's when you can get zapped. There's a little
And they'll
difference between
still
the wait.
admit you, even if someone doesn't sign as a responsible party, they'll
Oh,
still take you as a
absolutely,
patient. Okay.
absolutely. I mean, if a child is the power of attorney, they have to be very careful how they're signing the documents, and they're not signing as I'm signing in my individual capacity. No, no, you're signing as power of attorney if the parent absolutely cannot sign. So, but that's the way that you want to handle it. So.
I can imagine that you'd feel like you have to sign that for them to gain entrance into the skilled nursing
It,
facility.
and that's
So,
where some mistakes are made, that
yeah.
you're in an emotional state, you're concerned about your parent. They're throwing all kinds of papers in front of you saying you have no liability, huge liability. You don't want to sign it, and you want to make sure that that you've protected yourself, or even if you're a married couple, you want to make sure that what you're signing is not putting you at a disadvantage. And one thing that I want to warn folks about too is that I get a little concerned. You're distraught over the failing health of your loved one. Someone comes into your room in a long-term care facility and says, "Here's Bob. He's going to help you out." Well, Bob doesn't work for the facility. Bob works for a Medicaid application company, and they want to sign you up. And I've heard cases where they're calling people the night they've left the facility. And in one case, they even showed up at someone's home, which is incredibly unethical. So they just want to be careful. It's big business, and we're one of the most expensive states in the country. So it even heightens the reasons that we want to be careful.
So better instead of going with a Medicaid application company to go with an elder law attorney to
Ab
sign, to fill out the application for Medicaid.
Absolutely. It would be a conflict of interest for an attorney to represent the facility and the individual. That could not happen for an attorney. Why can this application company do it? And again, they are aggressive. A lot of them are from out of state, and they're hounding you to sign up. Well, that's because that's their whole sales pitch to the long-term care facility.
Well, thank you for clarifying that.
Absolutely,
That could be
absolutely.
confusing. Someone asked, what is a pour over will?
Pour over wills when you have a trust, oftentimes, to accept what's coming from the testamentary someone's estate, that it could pour into the pour over trust. And again, in case you didn't want someone to be in charge of the funds, if an estate was large enough, when the first spouse passes, it would be a way to try to reduce the taxable estate was with a pour over trust or a pour over will.
All right. Catherine asks, is a life use agreement, does that only apply to seniors who own their own homes? How does that work for folks who rent?
The life use would more pertain to a situation where there's ownership, and I'm glad you asked that question because you have to be careful about putting the life use in the deed itself. Because if an individual has a life use agreement, they transfer their property 10 years ago, and you're going through the Medicaid application process, that's one of the questions right in there is, do you have a life use? And there's a way in which the state attributes a value to that.
Yeah.
Number one, if the person's living in there. Number two, if they're selling it, it could be the state would be looking for a big chunk of the sale of that property. So you want to be a little bit careful if you decide to transfer the property. About there's ways in which there can be a separate life use agreement not recorded with a deed. So
All right. And then Al asked, regarding residency in other states, how closely is Connecticut monitoring the 6 months and a day rule? And how do they monitor that?
well, I guess that would be more a question for the Department of Revenue Services. I can tell you in the ballpark of Medicaid, let's say that someone was here in Connecticut, they had adult children living in Florida. They wanted to move to Florida and get Medicaid in Florida. If they were there for a day and their intent was to stay in Florida and become a Florida resident, they could do that. And the converse would be true too. If the adult children are here in Connecticut, the parents are in Florida or wherever, if their intention is to come back and stay in the state of Connecticut, then they could receive benefits here. The question was more of a taxation question. How closely do they monitor it? I do know that in Fairfield County, and I do know the state of New York is really getting aggressive and trying to monitor, where you are and what truly is your residence. So could be a bigger issue in the future if less funds are available.
Attorney Tully, if you are in the position where you don't have family members to manage your estate or will after you pass, are there attorneys who will sign on to do that?
Absolutely. And there's some, accountants, there's some other professionals that can act in that capacity. The nice thing about that is if the court is involved, they may require the posting of an insurance bond. There has to be accountings of what they're doing with the person's funds to make sure that their wishes are carried out. That's one of the positive signs of the probate court that doesn't always get talked about is that if you don't have a loved one, if you don't have any children, that you could have a professional who's going to take care of closing out your affairs and making sure your estate goes to where you want it to go. And that is, like I said, closely monitored by the court to make sure everything is the way it's supposed to be.
Would it be an elder law attorney or any attorney that
Well,
you,
it could be an estate and probate attorney. It could be an attorney experienced, dealing with trusts and things like that. Doesn't necessarily have to be an elder law attorney for that, but you'd want to make sure it's somebody you feel comfortable with, somebody who has got a good reputation, and is going to make sure that your wishes are carried out. So,
and are there any changes to the long-term care?
Yeah, she's saying that her rates have been increasing every year, sometimes twice a year. And
yeah.
yeah, what kind of claim could you make on that?
Well, I'm assuming you could make a complaint to the Department of Insurance. I mean, that's coming from the companies themselves. if they do make a rate change, they have to go through the process of a requirement there, but that's big business. I think one of the things would be just to complain to our congressional delegation, complain to our senators. I must say, that one person I know who's a lot of them are doing a great job, but Congressman Larson has done a wonderful job for seniors in the state of Connecticut. He's really monitoring like a hawk the Social Security programs. He's very aware in discussions I've had with him of the Medicaid program. So I'm very confident in that he'll continue to represent us and that he's done a great job. That would be a potential place to start too. Call his office, call Senator Murphy, Senator Blumenthal's office, and say, listen, I'm tired of this. I'm tired of this. And I did what I was supposed to do. Now the rates keep changing. Every single year something has to happen.
And I will say that CSEA was tracking a few bills in the Connecticut legislature that would help protect seniors in long-term care. So if we have another bill coming up, we will let folks know. And reaching out to your representative is really the best way. We need to get a law passed in Connecticut that will protect these insurance companies from just raising rates constantly until you're costed out of it. It's not even worth it anymore.
There is
So
a question. Do you have a recommendation for a single Connecticut retiree who lives in Rhode Island and owns her home and has a modest deferred comp account?
Well, the first question would be, are you a resident of Rhode Island or a resident of Connecticut? If they're a resident of Rhode Island, I would want to point them in the direction of a Rhode Island elder law attorney to make sure that there isn't some nuance in Rhode Island that the Connecticut attorney would not be aware of. There are some attorneys that are licensed in both states. And again, you wouldn't want to go to just any attorney. You'd want to deal with an attorney that is an elder law attorney and or a estate planning attorney that's familiar with both states.
I think we've answered most of the questions. I think we can do one more. Someone who is married with a living trust, what happens once they die or spouse and they both die? Who does the beneficiary of the trust contact for any legal matters?
Well, a lot of that would depend upon how the trust is drafted. If you are truly a beneficiary of the trust, you are entitled to get information about that. Trusts just by nature of how they're created are a little bit more not as involved with the probate court. Um, but if you are a beneficiary of a living trust, you are entitled to get some information about that. You'd want to find out who the trustee is. Is it a family member? Is it an accountant, an attorney, and find out what the specifics are about the trust. And if you were running into a wall and not getting any information, there are ways that you could even use the probate court to try to get, or the court system itself to get answers if you're being stonewalled.
Well, thank you, Attorney Tulley. You are always a wealth of knowledge for our retirees. I always learn something new, which I'm always grateful for. You're never too young or old to learn about these things and prepare yourself and your family.
Right.
We are going to do our best to make sure we schedule you for some of our chapter meetings. So our members can go in person and see you at these meetings as well, because we've come to the end of our session and we thank you very much. We're going to try to do our best to, you know, get the information out to people and we thank you for your time and
Right.
patience.
And well, it's always an honor to speak to your group. And again, on our website, KT Elder Law, there's a lot of our column that gets posted there on many different topics, so they can read up on that.
Okay, so we can access your columns on KT Elder Law.
That's correct.
And do you do consultations? Are they free consultations or are they,
Well, if
can
they
you
if they tell me
explain
they're
to us
from
a little bit?
CSE, if they're from your organization, we would meet with them for free.
Well, that's very generous and wonderful of you. So
Right.
Everybody, take note of that. All
Great.
right. We
Thank
thank
you
you again.
again. We appreciate.
My pleasure, my
Yeah.
honor.
All
Thank
right.
you. And thank you everybody for attending.
Yeah, we hope you learned a lot today. So if you didn't get your question answered, shoot me an email and I will try to do my best to get that answered for you as soon as possible. All
Thank
right.
you, everyone.
Take care. Take care.
Thanks. Take care.